Hey everyone, welcome back to the channel. Today we're jumping into a sovereign citizen case I honestly forgot was even still floating around until the court finally shut it down. And trust me, the payoff was absolutely worth the wait. Not because anything wild happened in the case itself, but because the judge's reaction to this sovereign citizen's strange, confusing answers is on a whole different wavelength. The ending turned out to be way more satisfying than anything I could have imagined.
We are on the record calling 21170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this trial, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written, on the envelope itself, it had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308, signed, and then it was a return to sender, Judge.
All right, Mr. Hurst.
We attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail.
And seriously, what does freeze even mean? Are you having some sort of episode? Because that's about the only reason anyone would believe that doodling edible highlighter on the outside of a discovery packet somehow wipes it from existence. You practically need to be convulsing on the floor and think that scribbling, "I don't accept this," could magically undo the legal disaster you built for yourself.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt.
And what exactly did you imagine was inside that packet you turned down? Honestly, refusing your own discovery might be one of the most bafflingly bad decisions you could ever make. All it guarantees is that you show up to trial totally clueless. No understanding of the accusations, no insight into the evidence, nothing. You basically chose to walk into a legal fight without even glancing at the weapon aimed straight at you.
Allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
I'm going to mute you, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can't finish my
You
statement.
will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand.
That part doesn't surprise me in the slightest. Based on everything we've seen so far, I'm not even convinced you could tie your own shoes without turning it into a near-death experience. You seem like the kind of person who'd get lost halfway through, bend down, lose track of what you're doing, and somehow end up chewing on a sock instead. And honestly, compared to your courtroom choices, that would barely make the top 10 strangest things about you.
I'm muting Mr. Hurst, and I will let Ms. Strickhardt say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickhardt, you were responding to Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in, all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refuse the packet, because I don't know if they're trying to contract with me or not.
Believe me when I say this. Sovereign citizens are financial sinkholes. They don't just drain money. They swallow logic, reason, and every dollar that wanders too close. Nobody with even the slightest hint of financial awareness would willingly get involved with you. In fact, anyone with functioning brain cells and a wallet would sprint the opposite way before letting themselves get sucked into the economic black hole you call a belief system.
But it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have,
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date, and sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules...
Sounds perfectly reasonable to me. If you're committed to destroying your own life, go for it. No one's going to stop you. Feel free to chow down on every last paint chip on the menu, if that's the road you've chosen. And trust me, Judge Robinson isn't jumping in to rescue you. By the time we're through, he'll be laughing at your choices harder than anyone else sitting in that court.
Question. They are claiming that this debt belonged to me, but they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right. I'm sorry, Ms. Strickhardt?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. I got a question. should they have received? Should they have sent me something before they sending me this package since the last court date?
Sir,
to verify that.
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, so she's going to send me a packet, and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said the discovery.
We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions. Same as
He's basically in the same mess she is, just without the 8+ years of legal training that might have helped him defend himself with at least a hint of competence. And that difference is exactly what matters here. Anyway, that wraps up his first appearance. After all his stubborn theatrics, he finally gave in and accepted the packet. Now it's time to move on and see what unfolds during his second appearance. And believe me, it only gets more entertaining from here.
On the record, this is 21-170-598. Midland Credit Management versus Kevin Hurst. Taking time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not enter knowingly, voluntarily, or intentionally. I do not accept the liability of any compelled benefit or unrevealed contract or commercial agreement without.
He's about to get a full serving of reality, topped with a generous scoop of nonsense pate and a side of questionable choice salad. And now we've finally reached the moment I've been hinting at throughout this whole video. And when I say it's fun, I definitely don't mean for him. I mean it's fun for the judge, because what about to happen is a kind of courtroom comedy you couldn't write even if you tried.
Anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary has been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking you first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan court rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the...
It's one of those rare courtroom moments that only gets more hilarious the longer you watch it. All right, guys, that brings us to the end of today's video. If you enjoyed it, hit the like button. If not, go ahead and drop a dislike. But definitely jump into the comments and subscribe with notifications on so you never miss any of the chaos we cover here. And once again, a huge shout out to HIMS for sponsoring this.